Hey everyone, I'm David Finz, and on this episode of the Cyber Insurance Imperative, we turn our attention to the state of Colorado, which just enacted the first comprehensive AI legislation in the U.S., and it could serve as a model for other states to follow. The Colorado Artificial Intelligence Act covers any person doing business in the state that develops, modifies, or deploys what is defined as a high-risk AI system. Now, what exactly is a high-risk AI system? Well, the statute defines this as any system where AI is a substantial factor in making a consequential decision around education, employment, finance and lending, essential government services, healthcare, housing, insurance, or legal services. Businesses using AI have a duty of care to disclose the risk of algorithmic discrimination and to take reasonable steps to protect consumers from known or foreseeable risks of discrimination. Businesses must conduct an annual impact assessment of their use of AI and document the steps taken to mitigate these risks. For their part, consumers have a right to be informed of the use of AI, a right to opt out of or to correct profiling for the purposes of automated decisions, and the right to an explanation for and an appeal of adverse decisions. Businesses that cure violations through internal testing or red teaming and are otherwise in compliance with the NIST framework will be able to assert an affirmative defense to such claims. Now, I have spoken in previous episodes about the fact that the use of artificial intelligence creates risks that go beyond the scope of cyber insurance and that other forms of coverage may come into play as well. This is clear from the drafting of the Colorado statute, which places such an emphasis on discrimination. And not many risk managers realize this, but employment practices liability policies frequently offer coverage for non employment related actions in which the civil rights of third parties are alleged to have been violated. These types of actions typically involve aggrieved consumers, but they can involve complaints from vendors as well. And this is important because claims of discrimination are typically excluded from cyber insurance policies. Less apparent is the professional liability or E&O exposure that this statute imposes. The Act requires that the developers of AI provide disclosures to their end users around the intended use of the model, what data was used to train it, and the known and foreseeable risks of deploying it. It's easy to imagine a claim where the end user goes back to the developer and alleges that the disclosure provided was inadequate and led to some financial loss or liability on the part of the end user. The key is making sure that these coverages fit together to form a seamless risk transfer system for your business, and that is where Alliant can help. We can review your coverages to identify any gaps and offer recommendations as to how to make your insurance program more airtight in the face of the coming wave of regulations and private party litigation arising from the use of AI. Want to learn more? Please don't hesitate to reach out. You can DM me on LinkedIn or email me at david.finz@alliant.com, and I'll be happy to take a look at your current policies in light of these new risks. This is also a good time to speak to the Alliant Risk Consulting team about bringing your policies and procedures in line with the NIST framework. And if your current broker isn't having these conversations with you, maybe it's time that you discover the more rewarding way to manage risk. Thanks for watching.